Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big warm hello to everybody in between. My name is Dan Balkaran, as you see on the screen there, and I'll be your employment lawyer for the next 30 minutes or so. I am an associate, as it says on the screen, at Samfiru Tumarkin, which is Canada's leading employee side employment law firm. Now, as always, if you need to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and you can always call us at 1-855-821-5900. Okay, without further ado, we got a couple of questions rolling in, so I'll address those, and hopefully some more come in as we go, and we can go through all of your questions. We had great questions 2 weeks ago and the last time I was here. And so I look forward to some more great questions from all of you today about all things employment law. Okay, let's cover the first question. I'm not going to say this person's name because there's confidential, sensitive information in it. So Jay says, I have been on leave from my job after having a miscarriage. My doctor has said I should not return to work until mid-May, but this will go past the 12 weeks my company says they offer. I assume you mean by that they're willing to pay you for in terms of time away. What are my rights in this scenario? Can my employer let me go if I need more time off? Well, we'll tackle the second question first. If you have a medical reason not to be at work, your employer should not or cannot simply fire you because of that medical reason. So both in the federal jurisdiction and the provincial jurisdiction, there's human rights legislation that says you can't be terminated due to a disability. Now, the key here is to make sure that you're listening to the advice of your doctor, or let me put this a different way. You're following the advice of your doctor with respect to your attendance at work, and that you properly paper your medical leave. So you need to ensure that you provide medical documentation, a medical note from your doctor to your employer saying, listen, doctor says I can't work until mid-May, so I'm not going to be working until mid-May. If the employer were to fire you in that circumstance, you'd have your severance rights available to you, and you'd also have human rights redress. Now, human rights, we'll say injury to dignity damages, are fairly small. I'm not talking about lost wages. I'm talking about injury to dignity. It's sort of the money you get for the egregiousness of being fired, because in this case, you had a medical leave because you had a miscarriage that you were still dealing with the after effects of. But they elevate for the egregiousness of the situation, and beyond that, they're part of the public record eventually when there's a decision. And certainly, if you had a court claim, it would, your lawsuit would be part of the public record. I don't know of any company that would want the bad press of, fired employee because female employee because she had a miscarriage, and then needed time off medically for that. I think that company would be in a world of trouble, and so I would be surprised if that happened. But ensure that you protect yourself as best you can by getting medical notes and providing them on an ongoing basis to your employer, and make sure that the time covered in the medical note is accounted for by the medical note. So what I mean by that is, if your doctor says you can't work for 2 weeks, if you need to not work after those 2 weeks, or you're medically unable to work after those 2 weeks, you need a fresh doctor's note extending that time that you provide to your employer. That way you're covered in terms of time, and just keep your employer updated. You don't want a situation where your employer can argue that you've abandoned your position, for example. So medical documentation from your doctor is your friend. I know it's not, or it is a requirement, we'll say. I know it's not always easy to get into a doctor, but in your situation, doctor will write you that note. If you can't get into your GP, you have to go to a walk-in clinic, get that note, provide it to your employer, keep your employer updated, and always have, and I'll just clarify this one point. Don't hand them the note physically. Scan it and email it to them so you have a record of it later. Okay, so if there's ever a dispute over who knew what when, you needed a paper trail of these things. And if you say, well, I walked in on X date to my office and handed them this medical note, that's a he said, she said situation. So properly paper it, send it by email, and have your medical notes up to date. In terms of the first question, so I don't know if you're federally or provincially regulated. certainly in BC, your employer does not have an obligation to pay you for 12 weeks when you're away on medical leave. Um, so if they're doing that out of their own goodwill. They won't go. I mean, I think an amicable, amicably, you want an amicable solution here if you can. So you can ask them, listen, this is much more serious than I thought. It's stretching on to mid-May. Can you please extend my pay to that amount? Um, and maybe they'll do it, maybe they won't, but you don't have an entitlement to it. Now, if you're on short-term disability, that period of time, I don't know if that comes from your employer or your insurance company, uh, your insurance provider, but in that case, that's going to be a set in stone amount. And then if you extend past that, if you have long-term disability, you may wish to convert into that. So, there are various different things you can do. You certainly, if you're talking about disability, you're going to want to examine the four corners of your uh, insurance provider, we'll say contract and booklet and everything that sets out your rights. You can always call them and find out. But if it's just if we're not talking about disability money at all, and just your employer's obligation to pay you that much money, they don't have it. It's entirely goodwill based. So, and just for everybody in situations where you're in an ongoing employment situation, if you can keep relations with your employer cordial and amicable, that only helps you solve problems as you go. Okay, thanks, Jay. And Jay, I wish you all the best with that as well. Question from, again, this is too, I don't want to breach people's confidentiality and privacy. So I'll just say from OB, does a small family-owned company have to pay severance? Short answer, I mean, yes. So, I mean, there's assumptions I have to make in your question. So, were you terminated without cause? Yes, the employer has to honor your notice obligations. The size and family-owned nature of the business does not make any difference. So, if you're an employee of an employer, regardless if it's a Fortune 500 company or a mom and pop bakery, your notice entitlement still holds true. And I just want to clarify you're still owed notice. And I just want to clarify your point about severance. So your legal entitlement is to notice. It's not to severance. Okay. So what's the difference between the two? Notice it's a bad idea. It's a bad idea for society for you to be thrown out in the street with no money and no jobs. The law has evolved this idea over time that your fall, the sort of economic devastation of losing your job needs to be cushioned a little bit. Okay, and so that's the idea that your employer owes you an obligation of a heads up, like, hey, OB, the bad news is we're going to terminate you in 3 months. The good news is we're going to continue to employ you for those 3 months and pay you a paycheck for that period of time. And hopefully you're not, and we'll give you time off to look for a job, and hopefully you're not unemployed for very long, if at all. That's the only thing you're entitled to. It's just, a period of heads up, and the period changes depending on your situation, but a period of heads up for you to go look for another job. But 95% of employers, in my, unscientific evaluation, terminate employees today. They don't provide the heads up, and the reason why is threefold. An employee who has been terminated is a sabotage risk for intellectual property and workflow and all that stuff. 2, the morale risk for the remaining employees who have not been fired. And then 3, an employer knows if they owe, say, 12 months of severance to somebody, 12 months of notice to somebody, and they say to that person, hey, listen, you can work here for 12 months, but we'll give you 7 in a bag of money right now. If you sign this release, you don't have to work for it. Almost 99% of employees will take the 7 over having to work 12 months. So that's the distinction. Your entitlement is to notice. However, if your termination date is today or some short period of time, the notice obligation converts into money. So the calculation of money, of severance and notice is interchangeable, but the legal entitlement is to notice. Okay. It's another one. So I'll just call this person TR. Is it illegal, i.e. criminal code, to lie on your resume? No, I'm not a criminal lawyer, but I would assume no. I think it is a misrepresentation, however, and you could attract civil liability if, in fact, you let's just say you were negligent in your job because of something that you lied in your resume about how you said you had a experience or skill or something that you in fact didn't have, and that caused you to create a loss for the business. That would be a bad situation. I I have not heard of an employer. Actually, I think I have heard of this, but it's very, very rare where an employer sues a former employee for misrepresentation by lying on a resume, and therefore claims damages for the loss of having to go through the expense of hiring and all that other stuff that goes along with onboarding a new employee. Um, Exceedingly rare, but certainly if you lied on your resume, I if there was a loss caused by the lie, I could see that. I mean, I don't know of that situation, but I could see that being a problem for the person who did that. But there'd have to be a loss, right? And that's, that would require some sort of negligent act, we'll say, that causes a loss for the business. Okay. TR again. I now have CPPD, and my apologies, I don't know what that is. Does this make my case for disability stronger? And would it mean that I have to get more money if I were to settle with my private insurance? I've been awarded long duration over 2 years to age 65 by my private insurer. Unfortunately, I don't practice disability law, so I can't answer that question. It sounds like you are on disability right now, so I'm not sure what it is that you're asking. And maybe the moderator can put up something about this, but I'm not sure if we do these live chats on the disability side of our firm. We certainly have a excellent set of stable disability lawyers at the firm, and so that would be a question you'd certainly want to direct to them. And in fact, if you email us, I only have the employment information in front of me to contact us, but if you email us at, oh, there you go, perfect. Next disability session, Tuesday, April 18th, 1 p.m. Pacific time. So tune into that, and then post your question there, and hopefully you will get an answer. And if not, you can. Sorry, I thought that was posted on the screen. It's not. So I'll clarify. We do disability live chats. The next one is April 18th at 1 p.m. Pacific time, 4 p.m. Eastern. Tune in the same way that you found this particular live chat. Post your question there. You should get an answer. And if not, the individual conducting that live chat will direct you to the appropriate email address or phone number at our firm to be able to handle your question. You can always, in sort of a roundabout way, if you email us at help@employmentlawyer.ca with your disability question, we'll make sure the correct people get it in the disability wing of our firm. So thanks, TR. I'm going to move forward now with other questions. Oh, there you go. There's the disability law Q&A with Mr. Darren Saul at 1 p.m. Pacific time. Okay. Question from CJ. If an employer cuts your hours to reduce your pay, is it looked at the same way as cutting your pay directly? So yes, the law treats it the same way. If it is a significant enough cut, either hours or pay, that results in a cut to your pay, then you are entitled to. Then you can pursue constructive dismissal. Constructive dismissal is. In effect, it's your employer has imposed a unilateral change upon you, which is fundamental to the terms of your contract of employment that you reject. Okay, so in simple terms, if your employer lowers your pay by 20%, that's a totally different contract than what you were working under before, and therefore the employer has effectively breached its own contract, materially breached its own contract, and therefore you have been effectively terminated by its actions. Okay, so the easiest ways to get to constructive dismissal are usually pay cuts. It's much harder when you talk about demotions, particularly when wage and title has not changed. But certainly, it happens frequently. Where there's a hollowing out of a position, where your title is still customer service manager, but you went from managing teams of supervisors to effectively just working in tier one customer service by yourself. That would certainly be a constructive dismissal. The So just to understand a little bit more of the distinction, the if your employer terminates your employment without cause, you have today we'll say you have an entitlement to severance, as we talked about earlier. Now, the amount of that severance is dependent on or contingent upon uh, what your employment contract says, and then from there, potentially your age, your length of service, and uh, and your position. But you have to be terminated to get there. Okay, and in a constructive dismissal, what's happening is you actually haven't been explicitly terminated, but in fact, the actions of the employer have de facto terminated you. Okay, that's what a constructive dismissal is, and so they're more complicated because so the underlying rationale of employment law is full employment, and so if you have a viable job, there better be a really good reason why you're walking away from it. And so it has to be a clear cut case. Well, I shouldn't say it has to be a clear cut case, but if you're wrong that the significance of the change was not material, then you effectively just quit your job. Okay. So, but on the other hand, if your employer reduces your wage by 20% and then you don't you don't claim constructive dismissal after about 2 months or so, 2 to 3 months, but I would closer in time. It's actually with a pay cut. There's nothing really to usually have a period of time to try on the change. But if it's just a pay cut, you know what it is, right? So I'd say it's much shorter. You'd want to pull the trigger on this probably within a month. Um, you've got a finite amount of time, 1, 2, potentially 3 months on the outside, to claim constructive dismissal, and after that time, you're deemed to have accepted it. So, if you've got a pay cut of 8%, yeah, I mean, could be, could not be, depends on the facts and circumstances. If it's 25, 100%, it's a constructive dismissal. But I think in situations like that, when it's hours, you need to find out if this reduction is permanent. Like if it like so, let's just say you pull the trigger and you're constructive dismissal. You say, yeah, they reduced my hours by 30%, and therefore my pay went down by 30%, and therefore it's a constructive dismissal. If if that proceeds to court, let's say, and the employer says, well, yeah, we reduced his hours by 30%, but we did it because we had this unique challenge in the business, and we were going to put his hours back to what they were in 3 weeks, and we told him that, that's probably not a constructive dismissal, right? So you need to find out, you need to get clarity about, is this a permanent situation? And listen, your employer is probably not going to provide you that clarity, but you need to do your best to figure that out. And if they can't provide you with any clarity, I mean, I think you're entitled to assume that that's a permanent situation. But listen, CJ, constructive dismissals are hard, and even with pay cuts, they're hard. And you got to understand that the moment you pull the trigger in your constructive dismissal, you don't have a job anymore. It's no paycheck coming in. It's a serious place to be at. So you need to make sure that you understand, or that you're prepared for that reality, and you understand all the nuances of what it is that you're trying to argue. So, or that you're claiming. So um, I think you should, before you do anything, and you need to do something fast if you do want to claim constructive dismissal. But remember, your severance entitlement might be limited. Let's just say you're successful with your constructive dismissal, that you have been fired by this pay cut or hours cut. Just because you did that doesn't mean your severance isn't limited to the statutory minimums, right? So if you got 7 weeks of severance coming to you, why would you trigger this? Depending on whether or not you have more jobs lined up or what have you. So you absolutely need to talk to an employment lawyer. If you want to talk to us, you can do so. Employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. But CJ, before you do anything, you need to talk to an employment lawyer. Okay. Chris asks, the new GM canceled my position, then gave it back after people complained. That happened to me once, actually, before I was a lawyer. Then he stopped inviting me to meetings, then changed my job, then forced me to sign off, even though I said it was impossible. I don't know what that last thing refers to. Maybe you can clarify. I don't know, sign off on what. So it sounds like he demoted you, then undemoted you, then you stopped going to meetings, then he changed the duties of your job. If you agreed to it, so there's a, I don't know about the rest of Canada, but there's a case in BC that it, granted it was for a sophisticated party, but the employee in that case consented. So we're still talking about constructive dismissal here, right? So has your employer, Chris, through its actions, indicated that it no longer intends to be bound by your contract of employment, or has it materially breached your contract of employment? Uh, it's hard to tell from what you've said. I mean, if they've, when you talk about a demotion in title and then an undemotion, and then they hollowed out your position, and you're not allowed to go to meetings, and maybe that's material for some reason, uh, it absolutely could be a constructive dismissal. But if you consented to these changes in writing, uh, that introduces a vector of risk, because unless it was on the spot, uh, a vector of risk that, well, you agreed to these changes, right? Like, so constructive dismissal is where you try on these changes for a little bit, and I mean, to be fair, some of this is just, it's not just changes, they're just materially reducing parts of your job, indicating they're no longer interested in the same working relationship you had before. Um, but if the primary horse that you're riding here into court is that they've reduced your position or your duties in some way, if you signed off on those changes, rather than trying them on for a little while uh, and then rejecting them, there is a case in BC that's dead against you on that front. Uh, but there are other cases, older cases, that are sort of in support of what you're saying. I don't. If you signed off on it, I'm not thrilled about that. So, but I would need more information. So I think, again, just like the last individual, Chris follows up. I'm on stress leave, and he sees your job posted on Indeed. Well, you certainly probably have a human rights complaint then. But Chris, you have a really complicated set of facts going on. You need to talk to an employment lawyer right away. If you want to call us, you should do that, or you need to call an employment lawyer immediately. Get a hold of us, employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. Who is the lawyer speaking? This is from TR again. So you might have missed the beginning. Dan Balkaran. Oh, you mean the lawyer speaking at the disability? It's Darren Saul. It'll be next week. Darren Saul, out of our British Columbia office. I believe that was April 18th as well. Okay, this person says this is a new question. There was a new contract in which went from 80 to 75 hours biweekly. I'm not sure who signed anything agreeing to it, but they gave any affected employees a one-time payment of $2,000. Okay, so I think I know what you're referring to, sort of, but it's sort of unclear here. I'll call this person S. So okay, your hours of work range from 80 to 75 hours every 2 weeks. Okay, so you're working slightly less than full-time hours. So does anything turn on that? We'll say, for one. No, because we've been talking a lot today about constructive dismissal. An hour changed by 5 hours isn't going to do it, I don't think. I mean, unless there was some material circumstance from a monetary perspective that, the person couldn't afford that reduction in hours because they were, had child care costs that they couldn't afford the pay cut, and they made it known to the employer, something serious that would have to turn on it. So a 5 hour reduction isn't going to do it, I don't think. Okay, but employees who so the second part of this that I'm gleaning from S's question is that employees who signed it were given one-time payments of $2,000. Give a one-time payment of $2,000, and so I think I don't exactly know what he's getting at here. He or she's getting at here, but I'm just going to cover that part. So, an employment contract is indefinite. It's different than a one-time transaction. So if I sell you my bike for $20, bike goes one way, $20 goes the other way, and we have a completed deal and it's done. Everyone goes their separate ways. Now, for that transaction to be enforceable in a court of law, fresh value has to go in both directions. Okay, so bike goes one way, that's value, and then $20 goes the other way. We have a deal. Okay, and then it's done. If it's bike goes one way and no money comes the other way, we don't have an enforceable agreement because no fresh value change hands in both directions. So if I were to sell my bike or give my bike to somebody, to you, and you didn't provide me any money for it, the law assumes it's still my bike and you're just holding on to it for me. Okay, so an employment contract or contract of employment is indefinite, unlike the bike example. It's labor for money on an ongoing basis, okay, on an indefinite basis. And so, what that means is, if your employer wants to change the terms of your employment, material terms of your employment that you've been working under for X amount of time, it has to provide you with fresh value to do so, because you're giving up a thing of value, which is a binding of your rights under a new contract, and so they have to give up something. The employer has to give up something of value as well. And if it doesn't, this new contract is not enforceable at law. So the one-time payment of $2,000, if it's not part of the usual raise ladder for the employee, that is sufficient fresh value to make the new contract enforceable. So just as a general tip for all employees out there, particularly long service employees, if your employer says, hey, you've been here for 15 years, we want you to sign this new contract, okay? Almost every time what that's about is that they've realized they have a liability to you in terms of severance. It might be significant, and they want to close that liability. So, maybe you've been there for 35 years and you have 24 months of severance coming to you potentially, and they want to limit that to 8 weeks. Okay? And so they say, here's $2,000 to sign this new contract. If you sign that new contract and you take that $2,000, arguably it's enforceable, or more than arguably, it is enforceable, and you've just reduced your outgoing value in the case of your without cause termination by effectively 22 months, okay, or potentially as much as 22 months. So if at any point in time you're an existing employee and your employer comes to you with a new contract, you 100% need to talk to an employment lawyer before you sign it. You need to understand what it is that you're signing and the value that you are potentially giving up. Now, if you do that, if you refuse, so let's just say you talk to an employment lawyer says, nah, you're giving up 22 months, potentially best day severance, don't sign this. You got to understand that your employer might fire you. I doubt it, because then they're going to have to pay you a huge amount of money, but they could. Okay. And so you need to be prepared for that. But 100 times out of 100, if your employer comes to you with a new contract, you take it to an employment lawyer right away before you sign it, and you review it, and you find out with that employment lawyer, and you find out exactly what change is happening to your rights. Okay. But if you sign a contract that you've been provided fresh value for, in this case, S is $2,000, you're done. That's a completely good contract. I'm going to answer Mary's question first, and then I'll see if I can circle back to you, Chris. Is the Ministry of Labor the same as the Department of Human Rights? No. Employment law is it's fearfully complicated. So the first division is, are you federally regulated or provincially regulated? 90 to 95% of you are provincially regulated, and therefore your governing legislation is the Employment Standards Act, and where it does not cover or apply, you get common law rights that sort of supplement or you're entitled to. And depending on that division between federal and provincial, you also have human rights protections under either the provincial human rights legislation that you have, or federal human rights legislation. So you need to understand what that division is to understand which legislation you get. Now, Ministry of Labor, what you're referring to is the Ministry of Labor. I mean, I don't know if you're talking about federally regulated or provincially regulated, but it would either be, well, I mean, each province is different. In BC, it's the Employment Standards Act, the Employment Standards Branch, or federally, you've got the Canada Labor Code that you're turning to, and the federal body that deals with complaints through that. So I hope that answers your question, but the division is provincial versus federally regulated. Once you figure that out, then you can know, and there's a good statistical odds that you're provincially regulated, in which case then you're talking about the employment standards legislation and your provincial human rights legislation as well. But you got to figure out that division first before I can answer that question fully. But I think that's enough for you to be able to understand. Sorry, and I'll back up here a second. Almost everything is in the provincial jurisdiction, but enterprises, businesses that cross, that are interprovincial in nature, so banks, telecommunications, that kind of thing, it can be federally regulated. If you Google list of federally regulated industries, the Canada.ca website lists them all out for you. And if you fall under one of those, you'd be federally regulated. If not, you'd be provincial. It gets really complicated in terms of the tests of, what is or is not federally regulated. But that gives you sort of a general idea. And then last question. This is Chris with respect to he was the individual that signed off on a reduction in his job title and responsibilities. I'm not sure it's a reduction, but I assume it is based on what he's saying. Yeah, that's a real problem. I mean, it's not necessarily a fatal problem to your claim, but if you had time to review it and then you agreed to it, were you under duress? Was some sort of pressure upon you? Were you in a fragile emotional state at the time? How serious was the change? Did they make you go from manager of customer service to janitor? Like what is it that you signed off on? But no, the fact that you did sign off on that, and by sign off, I assume you mean you put your name, your signature on a piece of paper that set out those terms. I actually, Chris, I had, and you're on medical leave now due to stress, and they're posting your job. I dealt with this exact fact pattern last year, and so I don't know if you're in BC or not, but certainly I have experience with that. If you want to reach out to me, but otherwise, and you can do so. You can just, if you Google my name, you can see my email address, and you can give me a shout. But if you're not in BC, certainly that's not going to be of assistance to you. But otherwise, Chris, you should talk to an employment lawyer right away. So with that, I think that's the end of all our questions today. Great questions. There you go. There's my QR code. If you, I didn't know I had one of those, but you can scan it and email in, and I'll take a look at it. But only if you're in BC, Chris. If you're not in BC, I'm not called to practice in other provinces, so I can't really be of assistance to you. But certainly, if I do think you should talk to an employment lawyer immediately, and if you need to do so, you can reach us at employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900, and of course, you can join me here in 2 weeks. I'll be back in 2 weeks answering all of your questions about all things employment law. But there it is. Join Chris Justice on Monday, April 17th at 1:30 p.m. Eastern Time. Chris is going to be laying down the law with all things, I should say Mr. Justice is going to be laying down the law with all things employment law. So tune into that and bring your great questions, and he'll answer them. But other than that, listen, I wish everybody thanks for joining us, for sure. Great. Wonderful questions as always. I wish you a safe and happy and wonderful weekend. And we'll see you in 2 weeks. Thank you.